Well, to make sense of the amendment, we are now being joined by legal practitioner Malaki Ugumadu. Thank you so much for joining us. Now, let me start by asking, do you think this amendment was done to take care of the controversy generated by Section 8412 of the bill, which prohibits political appointees from voting as delegates in party conventions or congresses for the election or nomination of candidates?
Well, it is now an era of unceasing amendments. First is that this particular Section 84 has become very controversial to the extent that even from the inception, the same legislature that passed it and the same president that assented his signature to the bill have requested for the operation. The Nigerian people are a bit taken aback regarding the extent of the unpreparedness. It's quite tardy that the same section that came into effect a few months ago is beginning to record this level of amendments after amendment. And don't forget, it is the same Section 84 or the subsection 12 that is the subject of litigation that has gotten up to the Court of Appeal. So the concern now is, to what extent can we therefore rely on the quality of jobs, quality of legislative drafting and content of the same drafting to advance our electoral processes? There's no doubt that the legislature, in this case the Senate, has the constitutional right under Section 4 to amend the Constitution, to amend the Electoral Act as they can do to any other legislative instrument. However, if within 2 months maximum we are recording amendments upon amendments with respect to the same section, then what comes to mind is, what was the quality of work that was done in the first place? I think that given an election year, the legislators have become somewhat at darker zone with the executive in relation to who controls the party machinery. And I think that is what is playing out with all of these amendments. That for me doesn't speak well to the consolidation of the electoral process and the electoral procedures that we have, which may give rise to a lot of litigations. I have just mentioned that Section 84, subsection 12, which targets political appointees, is a subject of litigation up to the Court of Appeal, as I speak with you.
So, of course, which brings me to my next question. If this particular amendment is passed into law by President Muhammadu Buhari, how much of a difference would this make on the Electoral Act as it currently stands, especially with just a little, it's just a little year before the 2023 general elections?
It will be gratifying to find out the content of the amendment they seek to effect. Because, quite frankly, when the nation was sensitized as to the anomaly or the perceived anomalies in Section 84, it was with respect and reference to subsection 12. Now, with respect to subsection 8, the Senate has also taken another step, as it were, since the bill has been passed, to effect yet another amendment to subsection 8. The whole issue is as to who is qualified to participate in the primaries of the respective political parties leading to the main election. And I think that what is at play is a contest, or if you like, a clash between the executive and the legislature with respect to who controls the political parties and the process of delegates to the same congresses, because that way they are able to position themselves in a way that gives either the legislature or the executive the advantage that enables them to pull the strings as the case may be.
Well, indeed, legal practitioner Malaki Ugumadu, thank you so much for your contribution. Thank you so much for your time.